Hi everyone, my name is Alexander Zalivako, and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching. So in today's presentation, we would look into a specific point of how international economic sanctions affect intermediated holding of securities. And we would do that by way of a case study analysis, where we would pick an example of one of the largest securities depositories, which was affected by international economic sanctions, namely the National Settlement Depository of Russia. And we would demonstrate how those sanctions targeting this depository as their primary purpose and objective, in effect, created substantial collateral effect on the private individuals who are not themselves the subject of sanctions. And we would specifically look into the matter through the following 4 points. I would first of all discuss the holding of securities in modern capital markets. What does it mean, intermediated holding of securities? What is it contrasted with? And what is the rationale for this structure? We would then discuss the sanctions which were imposed by major jurisdictions against the National Settlement Depository, or NSD. We would discuss the case of judicial review proceedings, which were started by NSD in the General Court, where various matters related to its designations were discussed. And we would conclude by looking into the current approach of the national competent authorities on the matter. So let us first set the stage for this presentation, namely the way securities, both equity and debt securities, are held by private investors in modern capital markets. The structure for such holding is commonly known as intermediary structure, and it is contrasted with so-called direct holding structure. So what is the intermediated holding and direct holding structures? The direct holding structure is a situation when investor holds securities directly from the issuer of those securities, and his shareholding is, or bond holding, is recorded in the primary legally constitutive document of the securities, namely their register. So the name of the investor appears directly in the register of the shares, or in the register of the bonds, and the register is the primary document whereby the issuer of the securities recorded their issuance. In the modern world, almost no investor will hold securities directly from the issuer. So, for example, if a Luxembourg investor wants to acquire shares in Microsoft or Ferrari, this Luxembourg investor almost never will appear directly in the share or bonds register of Microsoft or Ferrari. In the modern world, almost every individual investor will actually acquire securities through his or her bank account open in the jurisdiction of his or her residence. And those securities, being shares or bonds, will appear on that account, and a group of depositories will intermediate the holding of those securities and create a link between this account, open in our case in Luxembourg, and the ultimate share register of the relevant company, which securities our investors purchased, being Microsoft in the United States, Ferrari in Italy, or Deutsche Bahn in Germany, for example. So a chain of depositories will link the Luxembourg account and the register located in the jurisdiction of the issuer. This is done by depositories, and this is how currently almost any investment in any type of security will be structured. The reason why the market functions these ways are multiple. Among them is, first of all, the reduction of costs for individual investors. Just imagine the complexity of a private individual going to a foreign jurisdiction and opening a personal individual account in the share register of each company, which shares or bonds or other securities this individual wants to purchase. There would be a substantial amount of costs involved in traveling, legal costs, and any other related costs. Second point, which is related to the reduction of costs, is the ability to hedge the risks by way of diversifying the portfolio holding. Even for a relatively modest investor, it's easy to purchase multiple shares of various companies located in various jurisdictions through his account, single account located in the jurisdiction of his or her residence, and by doing so diversify his portfolio holding and mitigate any risks which can affect specific companies or specific industries. Inevitably, if the option would require that such investors goes to each and every jurisdiction where the relevant company and its register is located, the options for diversification for many investors would be limited. Final reason which this structure brings as a benefit to every individual investor is the ability to collateralize these investments for other projects. So, for example, an individual investor holding a portfolio of securities can pledge those securities to his bank and get a loan for his project, or a consumer loan, for example. The entire securities portfolio can be pledged under a single and relatively straightforward document in the jurisdiction of location of the account. Conversely, if the same structure would wish to be put in place with respect to multiple registers located in different jurisdictions, the cost of putting the structure in place, as well as the enforcement risks which the relevant banks would need to analyze, would make it very, very difficult for our investors to use those securities as collateral for any, for example, borrowings he would wish to make. It's important to understand that inevitably, as we need to link the register located often in a different jurisdiction from the location of our investor, there would be multiple depositories intermediating this holding. Quite often, we would have a structure of 4 depositories. There can be 3, there can be 5. I'm saying 4 the most common structure for the cross-border securities holding, because there would be one central securities depository located in the jurisdiction of the issuer. So, for example, in case of Microsoft shares in the United States, then there would be a international central securities depository which would link the US market to a foreign market. So, for example, in Europe, this function would be typically done by 2 international central securities depository, being Clearstream Bank located in Belgium, Euroclear Bank located in Belgium, and Clearstream Bank located in Luxembourg. So they would link European markets to DTC in the United States. And then the bank where our investor has her or his accounts would be connected to this international central securities depository by way of depository agreement. So all in all, we can see that there is a multiple depository chain which is in between the ultimate investor and the holder of the securities and the issuer of those securities. So in this overall structure, the role of the National Settlement Depository of Russia was the central securities depository for the Russian market, whereby it would link the Russian investors and securities brokers to the wider markets, like European market through the accounts with Euroclear and Clearstream, or other foreign markets. By all means, the NSD was not the only depository which was providing this type of service. There were many other banks which were providing depository services to the Russian investors. And we'll pick out in our case study the example of NSD for the reasons which I've discussed, namely this being one of the most important and most publicized cases where the effect of international economic sanctions on intermediated holding of securities was analyzed. So what happened with NSD is that already in June 2022, it was listed in the European Union as an entity subject to the EU asset-free sanctions. And accordingly, since the result of this, that all assets which are owned, held, belong to, or controlled by NSD have to be frozen within the European Union, all the accounts of NSD, being either own accounts or omnibus clients accounts, meaning the accounts in which NSD recorded the holdings of its clients and not of its own, all these accounts were frozen by the relevant European institutions, out of which the most relevant are the international central securities depositories, being Euroclear and Clearstream. The reason for the blocking sanctions against NSD in the European Union was the role it played in the financial markets of the in Russia, more specifically in respect of operating the payment system, providing access for the Russian sovereign, the Russian Ministry of Finance, to debt capital markets, both within Russia and outside, as well as organizing the holding of securities for the Russian investors. So the objective for listing National Settlement Depository was its role as a financial institution which plays a key function in the overall Russian financial structure. It was not the declared objective to affect those investors which were holding securities by means of NSD. These European sanctions followed by the US sanctions and the UK sanctions 2 years later, when the NSD was designated by OFAC to as the unleased in the United States, and the next day by the UK sanctioning authority, it was also added to the asset freeze sanctions. The effect of the US sanctions is extraterritorial, meaning that there is a risk for third parties unrelated to the United States of dealing with the US designated person. And the risk is that this party can be designated in its own name, the result of which is that even in the circumstances when no US nexus is identified, most of the parties would require some thought of comfort from OFAC prior to dealing with any type of assets for which NSD has custody. UK sanctions have no similar extraterritorial effect and purport to regulate relationships only to the extent the UK nexus is involved. But given the importance of the UK market in Europe, there are multiple securities which would have some sort of connection with the United Kingdom, being, for example, paying agents on the securities located in the United Kingdom, or custodians where the original, for example, global note on bond issues is deposited located in the United Kingdom. And this creates a potential argument that the UK nexus is established by way of participating of such parties, and the UK sanctions accordingly are also involved. It is important to know that in all three of these jurisdictions, there is no general license in place or no general regime in place which would allow individuals who are not sanctioned in their own name and who just hold the securities through the chain of depositories, where one of those elements of the chain or links in the chain is actually the National Settlement Depository, to withdraw the assets from this chain. Although none of the jurisdictions declared as the objective of the sanctions that these investors and their holdings shall be affected, none of the jurisdictions really issued a general license allowing these investors to withdraw these assets from the chain in an efficient, time-wise and cost-wise manner. All jurisdictions operate the system of individual licenses. And from the description which I made, we appreciate that quite often all three of them, potentially as jurisdictions, will be involved in deblocking the assets. This certainly is a very substantial cost and time issue for many investors who can have quite modest holdings intermediated by the NSD. In this respect, it's useful to look into the judgment of the General Court, which was issued in connection with the judicial review annulment proceedings brought by the NSD in the General Court following its designation. And for the purpose of our presentation, it's important to look into two grounds among multiple others used by the NSD to challenge the relevant regulation designating it to the asset blocking sanctions in the European Union. One set of grounds related to the what NSD argued erroneous appreciation of its role in the financial system of Russia. So NSD argued that its role as a central securities depository is overvalued, and many other banks can perform essentially the same type of services for Russian investors. Same argument was made with respect to the payment system which it managed. NSD made an argument that there are multiple other similar payment systems and they can easily replace the system of NSD, and there is nothing special about the system. Other arguments were made with respect to the role of NSD in the issue of Russian sovereign bonds within domestic markets and international markets, its role in the liquidity management of Russian treasury, and overall role of NSD with respect to making Russian economy attractive for investors. In essence, NSD argued that its role in these sectors is over-exaggerated in the analysis. The General Court, in essence, dismissed these arguments on the basis that even though there are other banks which can perform the same type of functions, this does not diminish the strength of the argument of the Council that the NSD is one of those banks and its role is important, and by accordingly sanctioning NSD, the Council puts pressure on Russia. The important for us is actually the second analysis, where NSD tried to challenge their decision to designate it on the basis that this decision disproportionately interferes with the property rights of NSD clients and the rights of NSD to conduct its business. The court dismissed the argument with respect to the disproportionate interference with the property rights of NSD clients on the basis that NSD is not authorized to represent the interests of those clients. Nevertheless, and importantly, a substantial part of judgment is actually dedicated to the analysis of the position of those clients, where the court seemed to acknowledge the position that many of those clients are not designated in their own name. they merely hold the securities by means of the NSD depository chain. And the result is that, although not designated in their name, the assets are frozen within that security chain as if they were designated. In addressing this point, the court emphasized the importance of derogations, which are available in the EU sanctions regime for these individuals to deblock their assets, and the importance that when considering those requests for derogations, the national competent authorities act in accordance with the Charter, and more specifically, with the obligation to respect the property rights of those individuals. So it seems that while assessing the legality of the overall effect which the designation of a large depository had on the intermediated of holding of securities with large depository, it was important for the court that the relevant sanctions mechanism provided for the possibility for such non-designated, non-blocked investors to release the assets from the securities holding chain. Nevertheless, the structure, at least in the European Union, works in a way that although the sanctions are introduced at the level of the European Union itself, the actual derogation requests are managed at the level of the national competent authorities. In this respect, it's helpful to look at the current approach of the national competent authorities in the major jurisdictions. And we can see that several trends can be noticed here. One of them is that in none of the jurisdictions, there is a general regime set in place which would allow the investors, by communicating with the relevant depositories, to get the assets deblocked. Such regimes are typically introduced by general licenses, compliance with which allows the investors to get the assets deblocked, but in none of 3 jurisdictions such general licenses were put in place. And this is in contrast, for example, with the situation when, for example, the investor has his or her assets blocked with a designated bank, when typically for example, United States or UK issued general licenses allowing such investor to close her or his accounts with this designated bank and withdraw the assets from this bank to the extent such investor is not designated in her name. The logic being that as the sanctions are introduced against the bank and not against the clients of the bank, then it's consistent with the purpose of the sanctions, and to a certain extent conducive to the purpose of the sanctions, to allow such clients to leave the bank as soon as possible. This was not the approach taken to the NSD, and although there was some uncertainty whether the general license issued by the UK with respect to brokerage accounts would allow to withdraw the assets which have NSD in its chain, the recent clarifications issued by OFC make clear that it's not, and that individual licensing procedure shall be followed to the extent the NSD is involved. In the European Union, one of the key national competent authorities involved in the discussions issued general principles for granting individual licenses, which is summarized on the slide, and where you can see that the conditions imposed are very difficult to comply, at least for the investors, which are small private individuals holding their modest savings through the chain of depositories. So, for example, one of the conditions was that the release shall require the sale of the positions, regardless of whether these positions are securities themselves or the cash. No mechanism was set up how the sale shall be perfected, who shall sell the assets at what price. No explanation was given how the sale can be done with respect to cash positions, for example, euro-denominated positions. There was a requirement that this application is supported by EU-based guarantor, which would ensure the compliance with EU sanctions and the factual accuracy of submission. And all in all, the period set in law for submitting the documents was 16 days, and that included both Christmas and New Year holidays. And I think we all appreciate that if we try to imagine how a private individual holding his or her private savings of modest amount through the chain of depositories, including the NSD, even if he would wish to comply with these requirements within the short period of time, it's highly unlikely to be workable. So all in all, the overall conclusion seems to be that while the legal framework of the blocking sanctions imposed against depositories seem to be based on solid legal grounds and operated on the assumption that the individual derogations will ensure that those sanctions target the depository itself and will affect its role in providing financial services to the Russian state. The reality of life proved to be more complex, and rather than affecting the capacity of Russian state, it actually affected the positions of non-sanctioned, non-designated individual investors holding their savings through the chain of intermediated accounts managed by depositories, including in our example, NSD. And I think that gives us an opportunity to have an overall thought of how economic sanctions work in law and in life, and what additional steps may need to be taken to make sure that the initial intention would be actually implemented in terms of practical effects. I hope that you found this presentation thought-provoking and useful, and I hope to see you during my next presentations. Thank you very much for watching.